All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Nous sommes en audience publique, Monsieur le Président.
Mr. President, we are in public session.
Mr. Keegan-Cartwell, there was a matter you had adverted you want to speak to, but before we get to that, one little clarification we want to make on hearsay. It is a matter that has come up, and it's a good thing we now have to come to grips with this issue. Just to be clear, the Chamber is not saying that we are going to have a watertight door that locks out hearsay. We are not saying that. But we are concerned if there's a huge amount of hearsay coming in through a witness, that in the end, it's likely not to be relied on a verdict in the case. With this particular witness, although it is a mixed bench from different traditions, but we are all agreed that we've had enough hearsay testimony from this witness. We now want direct evidence of what this witness observed as a witness. We are not saying that this means next witness will not be allowed to give hearsay testimony. It's a matter of the prosecutor or parties in general knowing when to play it safe with hearsay testimony. We do not want an open door policy, that endless stream of hearsay coming into the case. That's what we are trying to communicate, and we believe this should be clear. So from now on, let's hear, and we've had enough hearsay from this particular witness. Let's concentrate on what he directly observed. When we get to the next witness, then we'll see if the draft will remain open until we've had enough hearsay as well. That tells the prosecutor you need to pick and choose what hearsay you want to elicit from particular witnesses who come to testify. The same for the defense. It will be their turn at some point, and we will be doing the same thing.
Mr. President, we will act accordingly when it's our turn to cross-examine. And Your Honour,
not only cross-examine, but also,
of course,
examination in chief of your own.
Of course, and we will of scale and degree. But it also has an important additional function that it assists in the expeditious nature of the proceedings. Now, Your Honours, we're now on. We're going to carry on, it seems, and significantly after the temporal scope of the charges. And if we peel that away, the actual evidence relating to the charges maybe could have been finished in one session. The reason I raise that is, of course, it's for the parties subject to judicial control to ask their questions the way they think proper. But, Your Honours, we do ask that my learned friends look to these issues as to what is really necessary and important to prove the charges, and issues that really, by any stretch of the imagination, must be viewed as background issues. Your Honours, there's no complaint. Sometimes one wants a flavour of context. But, Your Honour, when one is spending such an inordinate amount of time on issues before and after the temporal scope of the charges, there are understandable concerns. I'm grateful.
Mr. Keegan-Cartwell. Oh, sorry. All right. Please proceed. Can we need to do this in 5 minutes, your submissions and any response. So can you make your submission in a minute or two, no more than 2 minutes?
I'm applied to Mr. President. Mr. President, in court on the 1st of November 2007, and Mr. President and Your Honors, we apply that you find us deserving of the exercise of the discretion given to this chamber by the appellate court on the 25th of October 2013. The application by Mr. Sang is that he is obliged to attend to his daughter's graduation, which is due on the 1st of November 2007, his 6-year-old daughter. And he had, prior to coming here, expected to be able to attend that graduation. But
what date?
Mr. President, so many people are telling me different things. Mr. President, he wishes to attend his daughter's graduation on 1st of November 2013.
That's what we understood, although you said 2007. But
I'm sorry, Mr. President. 2007 seems to be present at every corner of these proceedings. And Mr. President, his daughter, that is, he had expected to be able to attend that graduation in the period around 7th of November 2013, but apparently it was rescheduled. His request, and he had assured his daughter that he would definitely attend that graduation. He is afraid that if he doesn't attend it, the girl would not be able to understand why he's not able to attend, and the daughter has no comprehension of the ICC proceedings, and both the psychological situation of that daughter and Mr. Sang would be affected. Mr. President, the request is made for the limited purposes of him being present absent only on the 1st of November, no more day, no more less, not any other day, only that specific date. Mr. President, that is the application we make.
All right.
The court will recall that he has been sitting in court throughout, and he has conformed with all the terms and the conditions of the requirement for his attendance right from the year 2009 to date. Thank you, Mr. President, and Your Honors.
thank you. Prosecutor?
Your Honours, one is always reluctant to disappoint children, and I sympathise with my learned friend. However, there are limits within which courts must operate, and in my submission, the limits which the appeals chamber has set down do not allow for excusal of witnesses to attend family occasions. And while I sympathise with my learned friend, the 1st of November was always a date which was scheduled for the sitting of this matter. And in those circumstances, I regret to say that we must oppose.
May I clarify only two things, Mr. President? The notification that, in fact, the graduation is on the 1st came to him today on 30th, and I have a copy of the letter from the school. That's one observation I wish to make. My learned colleague has said there is no provision for excusal of a witness. I suppose he meant excusal of an accused.
That's the understanding, okay. we've had submissions on the matter. The chamber will issue a ruling tomorrow morning.
I'm most obliged. Thank you, Your Honor.
We will now bring down the shades and bring the witness in.
Nous sommes en audience publique, monsieur.
We're in public session, Mr. President.
Witness, welcome back. The prosecutor will continue his questions of you. Mr. Gesia, we to remain in public session?
I'd ask Your Honor that we go into private session for a couple of minutes, just to elaborate on that last point that was brought up by the Chamber.
We go back. We go to private session then.